Okay, good afternoon, ladies and gentlemen. Good afternoon, good morning, good evening, wherever you may be watching us. And thank you for joining us. Today, we have to start early again because of conflict, of scheduling conflict. Last week, we had to start early because I was going to be in a major trial in court. I'm pleased to announce that after the trial, I was able to get approved. It was an asylum trial. It was highly contested. But at the end of the day, it was a successful one. So I got the asylum granted by an immigration judge. Although the DHS indicated they are going to file an appeal, so they have 30 days to file their appeal, 30 days from last week, Wednesday. So whether they file it or not, that's their problem. But at least I've done my job. And if they file an appeal, we will meet them in court again. We meet them at the Board of Immigration Appeal. But for now, we have gotten the case approved. So today, again, I have a bond hearing at 1 o'clock Central Standard Time. So that is why we are starting early, so that at least I can have 1 hour to be able to do this. Because as we all know, things are changing on daily basis and the crackdown on immigration is not relenting. So we have to continue doing our best. So without wasting much time, let's start today. As usual, I'm going to start with a few updates and then go into questions and answers. So while I'm going through the update, if you have questions, start sending in your question because you stand a chance of getting your questions answered if you send it early. It is possible that I may not be able to answer every single question because, as I said, we are going to stop 1 hour's time. So if you have questions, just start sending them in early. Yes? What's that? Is that a problem? I don't know. Okay. Just let me know if there's anything you want me to. Okay, so as we said, if you have questions, send in your questions so that as soon as I finish the update, we go straight into the question. Because as I said today again, we don't have a lot of time. I have a bond hearing at 1 o'clock Central Standard Time. This is 11:35 Central Standard Time, so we are going to try as much as possible to answer as many questions as we can within the 1 hour. So, talking about the update, there's a policy alert. There's a policy alert. Thank you. So the first policy alert is that USCIS will review the marriage bona fide of each spousal relationship at the time the immigrant visa petition is adjudicated and at the time the adjustment of status application is adjudicated. Now, what that means is that they are going to be conducting preliminary investigation into marriage relationship, marriage-based petitions, even before interview. You know that currently, or maybe prior to now, because this policy is effective immediately, so I'm not going to use the word currently. If I use the word currently, it means I'm simply talking about the new policy. But before now, the policy is that immigration will review the application form, ask the applicant to go for biometrics, then schedule the applicant and his petitioner for interview. If there is a red flag during the interview, that is when they conduct investigations. But under the new policy, investigation is not going to be dependent on red flag. One, investigation is going to be on every single case. They are going to be conducting investigation into every single case. And secondly, they are going to conduct the investigation prior to the interview so that on the day of the interview, the applicant or the petitioner are going to be confronted with the outcome of the investigation. Now, the problem with that is that if USCIS believes that there is a fraudulent marriage, remember in one of our podcasts, we did mention that the Department of Homeland Security is setting up a special unit that will be making arrests. So what they are trying to say in essence here is that if they conduct the investigation during the interview, if they determine that the marriage is fraud, of course, the parties are likely going to be arrested right there at the interview. I don't know whether this is a scare tactics or not, but that is the new policy that they just rolled out now. So investigation is going to be conducted into every case of family-based petition. So that is all I will say on that for now. According to them, the purpose is to enhance USCIS capabilities to identify marriage-based fraud. Now, again, talking about enhanced capabilities, I'm actually in the habit of explaining to my clients, and I also believe that I do it once in a while, even on this podcast, that government have a lot of power. They do have access to a lot of technology. Through public record, they are able to determine a lot of things. They are able to determine where a particular person lives, even if you give them information about a different address. They have all these capacities. But now, under this new policy, they are specifically enhancing USCIS capabilities to identify marriage fraud. They are enhancing the capabilities to identify marriage fraud. That is all I'm going to say about this for now. And the next thing I want to talk about in terms of update is that there is a new BIA decision. BIA is Board of Immigration Appeals. They set a new precedent. And under the new precedent, they are saying that immigration judge can ignore parties' stipulation. The BIA has ruled that immigration judges can actually ignore parties' stipulation. This is a shocker to people like us who do practice immigration law and who do go to court from time to time, and we do have conversation and sometimes agreement, sometimes stipulation with the DHS lawyers. For the benefit of those who may not understand, stipulation simply means agreement. This is the first time that I will hear of a situation where two parties to a case will agree on the case, and yet the judge, who is supposed to be the independent arbiter, will say, oh, you know what, you can't agree. Oh, I'm going to ignore your agreement. That is exactly what the BIA is saying. So where the government lawyer and the respondent lawyer, where both of them agree and they inform the court that this is our agreement, the BIA is saying that the judges can ignore that agreement and go ahead with whatever the judge wants to do. Again, in my opinion, this is a very dangerous precedent. I never knew a day like this could come where two people who are fighting over an issue where they will agree and determine that, you know what, we don't want to fight anymore, let's do this. And then the judge will say, no, you cannot. But that is exactly what the BIA just said. And incidentally, it's a precedent decision. Precedent decision simply means that immigration judges must follow it. That case is called matter of JHMH. Matter of JHMH is a new decision, and it's a very, very dangerous precedent. The next update I want to talk about is that the AILA, American Immigration Lawyers Association, they have warned all their members, which of course I'm one of them. They have warned us that there is something going on right now, and that visas are being revoked over Charlie Kirk's related speech. For those who are living in the United States, you remember there was a guy that was shot. Was it last month? Or has it been? When was Charlie Kirk? I think it was last month, September. So this guy was shot, and of course, some people, they went online, look at all the negative things that he has been saying about other people, especially about minorities, about immigration, about a lot of things. So, people who are discussing it, DHS is now going after all of their comments. I'm just going to advise you, be careful who you have political conversations with. You may think you are just being innocent, saying it the way you feel. But according to American Immigration Lawyers Association, they just informed us to warn our clients that visas are being revoked because of Charlie Kirk's political related conversation. So be careful who you have conversation with, so that something that is not supposed to be your business will not end up affecting you. The next update, there's a new fee. Any immigrant who is seeking parole, they have to start paying $1,000. And this is effective October 16. That was last week. Effective October 16, everyone seeking parole, they will have to start paying $1,000. This new fee affects those who are already paroled, and those who are seeking parole will pay it once their parole is granted. If you submit an application requesting parole, you are not going to pay the fee until they determine that you will be granted. Once you are granted, then you have to pay it. If you are already being paroled, yes, you have to pay it. It's a new fee, $1,000 fee. Again, this is part of the big, beautiful bill signed by the president recently. So it is effective October 16, which was last month. Now, before I go into questions, there is one more thing that I want to say. There is a rumor that has been going on around. In fact, not less than 20 people have contacted me to verify whether it is true or not. And I keep telling them I don't know. I don't have a way of verifying whether it is true or not. The rumor is about is regarding people who gave birth in the US having their visas revoked, even if they pay all their medical bills. So, why am I bringing it up? Because I receive a lot of questions about it, and it is not impossible that questions will still come about relating to it even today. But I've submitted a request for verification to American Immigration Lawyers Association, because we do have officials who have direct communications with the officials, with the government officials. So I've submitted a request through our rumor tracker platform. So I've submitted a request to verify whether this is actually true or not. So as soon as we have a response, I will update us on this platform. Okay, so we're going to questions. However, before we go into the questions, there is something that we want to announce. I don't know whether this is the right time or I should hold on until we get to 12 o'clock because of people who may not log in early. What's that? Oh, okay. You have no. Let me see. Yeah, let me see. Let me see the announcement. But don't you think we should wait till 12 because some people may not join early? You know, this is early. Yeah, let's wait. Just remind me so that we don't forget.
Stay tuned because
Uh-huh.
this is going to be good.
An important announcement.
Yes, there's an important announcement, so just stay tuned. Don't log out quickly because it's something that will be beneficial to our listeners, especially our subscribers. So, but in the meantime, let's go into the questions. Please remind me. Also set an alarm so that I don't forget the time to stop today, so I don't miss my hearing. Okay, the first question. Oh, is this? Can you scroll up? Is this from the same person?
Yes.
How many questions?
7.
From one person.
7 messages, and I think she's giving you the background, but it's a long one.
Okay. Let's see. Let's start. Let's start from the first one. Oh,
I don't know where it's not. Okay, there you go.
okay.
She doesn't want her name to be shown on the screen.
No, it doesn't matter. Good day, sir. Please below is explanation of my daughter document review questions. Move it up a little. My daughter is F11, unmarried daughter of a U.S. citizen. Please, we are in Nigeria for our interview next week. This week at the document review, they said she should bring USA police clearance. Is USA police clearance needed for her since she lived in only USA since 2008, has no criminal record? She's 31. I did I-130 and I-601 waiver for her before the NBC gave her interview date. The NBC told our immigration attorney we used that she don't need recapture another fingerprinting since she has already done that before and they have it in their system. But when she went for the document review, they asked her for USA police clearance. Please, what do we do, sir? Our interview is early next week and she's already in Nigeria. Thank you so much. Okay, this is still, okay, is there USA police clearance, sir? What is USA police clearance? How do we do that? Where do we do the fingerprinting for that? If she's already in Nigeria, will she ask the embassy for fingerprinting? Scroll up. Please don't show my name on screen when live start. Thank you. Is that the last one? Okay. First and foremost, if the beneficiary, as you indicated, lives in the US, police clearance is not required because that is the whole essence of fingerprinting. Once they run fingerprinting, they will see if this person has any criminal matter here or not. However, having said that, since they have specifically requested it, to tell you, in my experience, they have never requested for it. In my experience, in my entire immigration life, nobody has ever requested this. However, since they specifically requested it, what I will tell you to do, there is in the US, police record, you can get police clearance certificate multiple ways. You can get it through the Department of Public Safety in the state where you live. You can get it through FBI fingerprinting check. As far as I know, the United States Department of Homeland Security themselves, even including the embassies, the Department of State, they rely on FBI fingerprinting background check. So since they have requested for it, go online. There is a page. Is it fbi.gov to schedule FBI fingerprinting check?
It's a little bit more complicated than that. Yeah, I can post a link in the description.
Okay, what I would just advise you, I mean, like I said, this is interview coming up tomorrow. So, and the applicant is not in the United States, so there is not a way to do it. But to satisfy the officer who may have asked in error, but just to show that you did not ignore the officer, go online. I think it should be fbi.gov. I can't remember the procedure.
History.
Okay, what you can do, I mean, you can go online onto Google and Google how to obtain FBI fingerprinting background check. So once you Google it, it should take you. Please don't use private people. There are a lot of private people online who are looking for vulnerable people to exploit. That is not what I'm saying. I'm talking of the government. If I'm correct, it should be fbi.gov. That should be their website. So go to fbi.gov and request a fingerprinting background check. Of course, your daughter is in Nigeria, so you request it. They will tell you what the procedure is. They will tell you. Ordinarily, if you are in the US, they will have told your daughter to go to the nearest post office to go and submit herself for fingerprinting at the post office. But because there is no, I don't know if they will allow that in Nigeria. I don't even think so, because I think I do know somebody. I know somebody who did it in Canada before.
Yes.
Was the fingerprinting done in Canada?
Yes.
Okay, so it is possible. It is possible that they may allow fingerprinting from Nigeria, but go ahead and go to fbi.gov, get the information that is required to the officer, the effort that you made in getting this done. But usually it is not required if this person has been living in the US. But let me also tell you, for the purpose of immigrant visa, fingerprinting is required for every country that an applicant has lived since age 16. So I'm not sure if your daughter has been living in the US since age 16. If not, you may need even FBI police certificate from other countries, because it is from every single country that your daughter has lived since age 16. But what I will do is just what I told you. Go to fbi.gov, request a fingerprinting background check, and they will pay the fee and let them know that you are applying from outside of the United States, and they will tell you if there is any available space, a place where the fingerprinting can be taken in Nigeria. If your daughter were to be in the US, this is a process that you can actually get done within 24 to 48 hours. So it is not something that is difficult to do. The only aspect now is that you are going to be doing it from Nigeria. But again, if you start that process today is still Wednesday, even in Nigeria. So if you start that process today, go online, fbi.gov, request fingerprinting background check. You pay the fee. I've been told the fee is $18. Pay it.
And then 50 at the place where they obtained the.
Well, you can't determine that when they get there, because this is outside of the US. So, I've been told that you may be required to pay some fees where the fingerprinting will be taken, but we cannot determine how much that will be from here. In the US, it's about $50, but since we are talking about Nigeria now, I have no idea how much that will be. But at least that is the fastest way that a police clearance certificate can be obtained. So just go through that process. Even if the process is not completed, you show the evidence to the officer during the interview that this process was instigated. At least you commenced it. Okay, next question. Good day, sir. Please, does EB2NIW self-petition require affidavit of support to adjust stay for self, spouse, and children? Has it been approved? No. Employment-based petitions do not require affidavit of support. If you have an approved EB2NIW, that is self-petition. That is employment-based. Every employment-based petition do not require affidavit of support. Go to the next question, please.
It's right there.
That one just say thanks for all you do, sir. Okay, thank you.
Read it.
Yeah, thank you. Good afternoon. God bless your entire team. Amen. Please, when is my VAWA going to be finalized since I got approved almost 2 years ago? Well, if your VAWA has already been approved, if all you are waiting for is green card, do a service request. If it's not working, use congressional intervention, because usually what delays is the VAWA itself. But if the VAWA has been approved, then you can follow it up with a service request or use congressional intervention. But right now, I-485 in some cases, the processing time. Do you have an idea? Processing time for I-485? I know is. Can you please check?
Do you think it will depend on the local office, how busy they are? Because
Well, that's also a factor. But usually, VAWA takes an average of 2 years. So if the
it's 4 right now. Almost 4.
I'm talking about average. Some cases may take 4 years or even more, but the minimum average of 2 years. So anyway, I don't know if this adjustment was filed concurrently or not. Well, don't let me guess, because there's a lot that we don't know here. But what I would just advise, if the VAWA has been approved and the 485 has been pending for some time, do a service request. If it is within processing time, it will not allow you to do service request. But if you do the service request and it goes through, then it means it is outside the processing time. And if it is outside the processing time, if they don't do anything after the service request, then go ahead and seek congressional intervention. That would be my advice. Next question, please.
It's 12.
What?
It's 12 if you wanted.
Okay, let me answer the next question.
Okay.
Next question, please.
It's on the screen.
I did not receive approval notice for I-539, that is change of status, but approved as shown in case status check. Please, how do I get it? I did e-request, but no. Have online account, you can log into your online account and then you look under the column that says document. A copy of the approval should be there. Again, I don't know if this person moved or you changed your address and then maybe they mailed it out and it was returned. Another thing, I don't know if this person has a lawyer, because normally, if you have a lawyer who filed it, the original approval will be sent to the lawyer. So if you have a lawyer, the best way to get it is to get it through your lawyer. Get a copy from your lawyer, because they will always send the original to the lawyer. But if you don't have a lawyer, check if you have an online account. Log into your account and then look for the column that says document. Then you get a copy from there. And also, if you try all of that and you do not get it, then you can probably, since you already said you did a service request, maybe you follow it up with another e-request. But if you have a lawyer, I'm sure the original went to your lawyer. And if you have an online account, you can also get it from your online account. Next question, please. Can you explain the timeline after submitting T visa application? What is the quickest approval time you have seen? That is that is something. Answering this question will involve complete guessing. Complete guessing. T visa, they take their time. It goes forever. Do you have an idea of the average time? Okay.
When she sent that follow-up question.
Okay. What do,
No, the gray one.
okay. Can you apply for advanced parole while T visa is pending? I don't think so. I don't think so because you
Depends on how they came in, don't you think?
yeah, there's a lot of things that has to do with T visa. So I don't know. Did this person come in legally? Did you come in with a visa? Did you come in without inspection? At what stage did the trafficking occur? Was it after you got into the US? Was it were you traveling? Oh, 25 months. Aha. Yeah, so I was told that it's an average of 25 months, the processing time. So I don't know how long this one has been pending. But as far as advanced parole, I don't think so. I think the T has to be approved before you can get advanced parole. But this is one answer that I'm not 100% sure. So I will need to verify. I will need to verify and get back to you before the end of the podcast.
No. While it's pending, it will be considered as abandoned.
That is if you travel without it.
No, they don't issue travel documents while the T visa is pending.
I don't think so too, but I just want to be 100% sure. Yeah, I just want to be 100% sure. Yeah, so it has been confirmed that no, you cannot get advanced parole while T visa
You have
is.
to wait for the approval.
Yeah,
to
you
apply
you,
for
you,
re-entry permit.
yeah, you cannot get advanced parole while it is pending. Next question, please.
Did you want to do this now?
Yeah, but in the meantime, go to the next question.
That's the next question.
What's the next question? What do you advise on use of money order than the debit card authorization? Petition received on 27 with money order. Will it be accepted on? I believe that USCIS is already implementing the electronic payment system. It's effective.
Let me see if they're still.
Can you
accepting
check the
Yeah.
effective date? Yeah, because from the effective date, they will not accept the money order. So if you are just thinking of filing right now, I don't think money order will be accepted. But confirm the effective date. I know that I think they have started the electronic payment system. So I don't think they will accept money order. But we'll just confirm. While waiting for confirmation, I did mention, and I wanted to delay because of those who will join us at 12 p.m. so that they may not know that we started early, even though everyone who subscribed will probably know because that's one of the benefits of subscription. You get notification that we are live. Last week, we started early too because I had to be in court. I announced that I had a major trial and I had to be in court. That was why we started early. Today again, we are starting early because I have to be in court by 1 o'clock. Today is going to be a bond hearing. But I wanted to give a feedback. The trial that I did last week, Wednesday, it was very strenuous, highly contested, but to God's glory, I got the case approved. It was an asylum case. It was keenly contested. In fact, throughout, even after the judgment, the DHS indicated that they are going to file an appeal. I'm not bothered by the appeal. They have 30 days to do it. So 30 days from last week, Wednesday, we wait and see. But the most important thing is that I succeeded in getting the case approved. So we have decided going forward, my team, they suggested a recommendation which I don't have any objection to. So I'm just going to read their recommendation. Next week, during the podcast, we are doing something we don't normally do, and it is just for our podcast community. We are giving away a free new client consultation live on the show. No, how can consultation be live?
No.
We're going to be
The
announcing.
giveaway.
Yeah.
Okay. So we will be. You mean we'll be announcing the winner? You mean?
Yeah, so the giveaway will take place next
Because
week.
this one is a little confusing. If you tell somebody you are giving consultation live, I'm not going to be giving my entire history over live program.
So the giveaway will happen next week.
Yeah.
And during the live podcast, we're going to choose the winner,
Yeah.
a random winner. But the requirements are there.
Okay, is it the requirement are those one in the green?
Yes, there are 3.
Okay. Let me say it
Yeah.
the way I understand it. Okay. What we are saying is that for our subscribers, we are going to be giving free consultation. I'll be offering one free consultation. How often is this going to be?
Once a month.
Okay. We'll be offering free consultation once a month for any of our subscribers who is selected. Now, what is going to be the requirement? The requirement is that the person to be selected must be a subscriber, either existing subscriber or a new subscriber. It doesn't matter. For as long as you are a subscriber, you stand a chance of being selected. And the second requirement is that the person must tune in live next week, because next week is when the announcement is going, the selection and the announcement is going to be made. So you have to be live before you can be selected. And 3, what is the third requirement?
They need to comment during
Oh.
the live podcast.
Okay, today or next week?
No, next week.
Okay, by next week, the subscribers will need to comment free consultation in the live chat during the show.
That way we will know that they're interested.
So that is what will give us confirmation that they are live.
And
So
that they need it.
yeah, they are live and they also need it, because we don't want to give free consultation to anyone who may not need it. We really want to give it to people who genuinely need it. So that is the announcement. So there will be one free consultation per month going forward. So we are starting the selection process next week. So next week, just make sure you log in, you are live, and during the program, you just chat free consultation. That will give us the information or the indication that you really need free consultation. If you really know you don't need it, you don't need to deprive those who need it. So this is for those who actually need it. We just want to, as a way of giving back, we just want to do that too as additional way of giving back. Free consultation, one person per month going forward.
And then let them know that we're going to squeeze them into your busy schedule.
Okay.
We're gonna take
Okay, let's go into the next question. This is taking too much time. Okay, I've been told that if we offer you free consultation, don't worry about appointment schedule. I know that my schedule is extremely busy, but if you win the free consultation, we will definitely accommodate you before the next podcast. In other words, if you are selected next week, you will get an appointment either next week or the following Monday or Tuesday. Definitely, the appointment will be before the next podcast.
just let them know that it's going to be from next week, because people are already commenting.
No. This is going to be from next week, not today. Not today. It's going to be from next week.
Next week, yes.
Yeah, it's going to be from next week. So just make sure you meet those requirements. Okay, can you go to the next question, please?
Yes.
Okay, I have my vowel approved. I would like to go to school. What do I have to provide for the school for the admission. Well, VAWA is not a status. VAWA is not a status, so you can't use that to go to school. What you can use is do you have I-485 that is pending, the original receipt notice of your I-485. You also need, if you also have employment authorization, and then you can also now add the VAWA approval. But VAWA by itself is a petition. It's not something of status. So it's not something that can take you to school. However, the combination of your employment authorization, your original receipt notice of the I-485, and then the approved VAWA, those three things you can show to the school in order to go to school. Next question. Good morning, sir, and thanks for giving back with your team. Please, thank you. You're welcome. Please, sir, I went for my marriage-based USS interview with my wife, and the interview went well. Not until the officer said his system is showing I left since May 2016, in which I came into US in April 2016. What can I do? So what did the officer say? I mean, if it is possible that the officer may say that because there was an error or something, but I don't think they can use that as the basis of denying if you didn't leave.
Maybe check the travel history on the I-94 page to see if it shows like an exit.
If the person didn't travel, there's no way it's going to show an exit.
Remember, okay.
Well, this was in 2016. As at 2016, they were already using electronic I-94 as at 2016. I know that during the days of physical card, some people will remain in the US and they will still submit the I-94 card. If you submit the I-94 card, the record will show that you departed, even if you are here. But since electronic I-94, I don't think that was possible. Well, there are three things I will advise you to do. Number one, go online, cbp.gov/I-94. Pull your I-94 and check your travel history. If your travel history indicates that you left and you didn't leave, the next thing you need to do is to contact CBP. I'm assuming that you have a lawyer. Your lawyer can also help you with this. Contact CBP and let them know that they have error in their system, that you have remained here, you did not depart. So let the CBP amend the record. The third thing that you need to do, which is the most important, document evidence that you have remained here since that time. Your lease, where were you living, rental history, employment history, driver license, ID card, did you go to school, banking record, what other thing, phone record, your phone record, anything. No, you may not file tax. Anything that can show that you are here. I don't see how you can live here without having a phone. So phone record, go to your carrier, go to the company, tell them that you want the details of your phone record so that all the calls that you made, it will show where you are, where those calls were made. It will show all these things, the time and everything. Whatever can prove that you are here physically. So start gathering all of that. It is also good that you have that before you approach CBP for correction. But more importantly, if you have those things, if USCIS eventually issue notice of intent to deny, because even if they believe that you left, they will still have to issue notice of intent to deny before they can deny. So that when they issue notice of intent to deny, because they are going to give you only 30 days to respond, so you will now have time. You may not have enough time, so you start early now to gather all those things. So those are the things I will recommend that you do if you know you didn't leave. So that is it. Do those three things. One, check your travel history from CBP website. Two, if there's an error, contact CBP and request them to rectify the error. And three, gather evidence that you have remained here since, what was that? Is it May? Since April of 2016. So gather all those evidence. More importantly, telephone record, banking record, even if you have a car note, whatever can prove that you have been here, things that you cannot do from outside, those things will show that you are physically living here. So those are the things you will need to submit or gather together. Next question, please. Afternoon, sir. Does someone have to report dismissed temporary peace order on Form I-485 for the question that said, have you ever been cited or charged? Yes, it is better to include it, especially if there was a record of it, because normally it depends on what the issue is. Every case is different, and this I always tell my listeners and my clients. There are no two cases that are the same. Every single case is different. Somebody may get two people may get a speeding ticket, and that ticket may cause immigration problem for one and not cause for the other. In fact, let me say it differently. Three people may have the same problem, the same situation. Three people get speeding ticket, and it can have three independent consequence or impact for each one of them. For example, one person, the first person, speeding ticket, the person paid the fee, case closed. No arrest, nothing. Case closed. Second scenario, another person got the speeding ticket, went to the municipal court to pay the fee, request that the fee be reduced. They place the person on probation, 90-day probation. Don't do this. If you don't get another ticket within the next 90 days, it's not going to go into your record. 90 days probation, case closed, fees paid, no record. The third person, you got the same. In fact, I'm going to give 4 scenarios. So the third scenario, you paid the speeding ticket. You didn't request probation. You just paid it. It went into your driving history. Even though there was no arrest, there was nothing, but the record goes into your driving history. That is a different implication as well. Then the fourth scenario, you got the speeding ticket, you didn't pay it, or maybe you thought you have taken care of it, you forgot, and then one day you are stopped or you are arrested because there is a warrant of arrest. Now you are taken to the police station. You quickly pay the fee and you are released, case dismissed. All those 4 scenarios, they have different implications when it comes to immigration. Even though each one of them is the same speeding ticket, each one of them, they probably didn't go to jail, but they all have 4 different scenarios. Now, for the one that paid it and requested probation and followed through with the probation, there is no record of it, there was payment. That one is unlikely not going to have any immigration issue, because even if the person didn't disclose it, because there is no record, there is nothing that can come out of it. Now, the one that paid it, the one that paid the ticket, but didn't request probation. Now, there was no arrest, there is nothing, but it still goes into your driving record. Now, if immigration asks you, have you ever been cited? And you say no. If for any reason, at any time, even after you have gotten your green card, if at any time they discover that record, that state record that has a record that you are once cited, if they discover that record, then it means that you lied. That creates or that causes complication. Again, it doesn't matter whether you now have your green card or not. It may be at the stage of citizenship that issue may come up. Now they will accuse you of lying because during citizenship, there are other questions. Have you ever lied to an immigration officer? Now they will accuse you of lying to immigration officer and they can disqualify you on the basis that you lack good moral character. The same way, the one that neglected to pay the ticket and it led to arrest, that one is even worse because for that one, the arrest will show up in your FBI fingerprinting. So if you don't disclose it, the FBI record will show that you have an arrest. So all these things, there are no two cases that are the same. They are different. So what does it cost you by just disclosing? Yes, I've been cited. It's not a disqualification for your green card, but disclosure is very important. Next question, please. Good day, sir. For a wife waiting for my fall interview, immigrant interview, under EB, follow to join. Is virtual wedding a problem to be concerned about? Husband came back tonight. Oh yes. There's a new policy on that. The reason I didn't mention it today is because I've not had time to go over it. I've not read it. I'm probably going to be discussing it next week. Please remind me. There's a new policy against virtual wedding. Yes, virtual wedding will be an issue. There's a new policy against it. It doesn't matter what the law of the country says about it. Yeah, there's a new policy against virtual wedding.
That's the second question.
Okay.
Same person.
They both took wedding pictures. If it's a concern, how do you think the wife should explain this during the interview in Nigeria? Well, I can't tell you how to explain it because there are so many things that I don't know. Because Nigerian law is not the same as US law. Under Nigerian law, there are 5 types of marriages that are valid, that are legal. So I don't know which marriage you are referring to here. I don't know what document you submitted as a form of evidence of your marriage. Because if it's a marriage under the Act, there is no explanation. Virtual wedding is not acceptable under the new policy. The next marriage is church wedding. And I think it's better for me to hold on till next week to answer this question when I'm 100% familiar with the new policy regarding virtual wedding. Please remember.
Do you know?
Huh?
Do you know? The short?
Well, okay, yeah, remind me. Just remind me. Yeah, I will note this question too so that I can repeat the answer next week. But I do know that virtual wedding is a concern right now. Yeah, let's go to the next question. I will answer this when I have more fact on the new policy. Mm-hmm. Yeah, I saw the new policy, but I've not had time to go over it and digest it. Okay. Hello, sir. Can someone whose B1, B2 visa was revoked in Nigeria appeal? No. The visa was revoked for having a child in US 14 years ago. The person paid all medical and hospital bills. No, you cannot appeal. Every non-immigrant visas, including B1, B2, F1, M1, L1, H1B, O visa, P visa, every non-immigrant visa, they are 100% discretionary. There's nothing anybody can do about it. No lawyer can change it. No court can even change it, because the court has said that where the Congress authorizes discretion, the court cannot tell the officers how to use their discretion, because the moment you tell them to use the discretion one way or the other, it is no longer discretionary. So it is not something that you can do. Unfortunately, too bad, there's nothing you can do other than maybe you wait until your son turns 21 and then he can petition for you. That one is not a discretionary matter. Another thing you can also do, if you have an urgent need to come to the US, you can apply for a non-immigrant waiver. But again, that one too is discretionary. So there's really nothing you can do in terms of a discretionary visa being revoked. You see, this is similar to the rumor that I raised earlier about people's visa being revoked because they have children here. Yes, I've had a couple of that, but I don't know whether it's a policy or this is just at random. But I've submitted a verification request through American Immigration Lawyers Association. So we will notify, I will notify my listeners next week by God's grace with our findings. There are so many things I've asked you guys to remind me. Please don't forget. That is one of them.
No, I have, yeah.
Okay. So next question, please.
Yeah, I saved it. And then
Okay, is it the one of three? What?
we have 1 minute.
Oh, okay. Okay, thank you.
You're welcome.
One of three. Asylum filed March 10, 2019. Enter with B2 visa March 10, 2018. That is 1 day late. Is the asylum filed within the 1 year stipulating?
Okay, stipulating there. 2 or 3.
Okay, that's the first question. The answer to that is no, because March 10 to March 10 is 1 year and 1 day. March 10 to March 9 is 1 year. So to answer your question, it was filed 1 day late. The next question. An employer is willing to file an EB3 on my behalf, and they said it's going to take 2 to 3 years. But based on my I-94, I cannot file for adjustment of status, but a consular processing in Nigeria. It means I have to go to Nigeria whenever visa is available and interview schedule. What happens if the immigrant visa is not approved? This is a very good question because, that's part of it.
Yeah, 1 or 4.
And I don't have a valid visa to come back because the earlier issue B2 is expired. What do you advise? Okay, this is a very good question because it is one of those questions that highlight the importance of overstaying, in the effect of overstaying in the US. The law is that whenever you come into the US with a non-immigrant visa, either visiting visa or any non-immigrant visa, even if it is employment visa, any visa that has expiration date or has specific purpose, like F1 that may not have expiration but has a specific purpose for you to go to school. Every time you are out of status, if you overstay for a period of 1 day but less than 180 days, anytime you step out of the US, you are barred from returning to the US for... No. Let me explain it differently. Every time somebody overstay in the US for a period of 1 day, but less than 180 days, 180 days is 6 months. Anytime you step out of the US for the purpose of adjustment of status, not for the purpose of renewal of a visiting visa or non-immigrant visa, but for the purpose of adjustment of status or consular processing immigrant visa, a period that is less than 180 days is considered grace period. Now, every time you overstay for a period of 180 days, but less than 1 year, every time you step out of the US, you are barred from returning to the US for a period of 3 years. That means you cannot get visa in Nigeria or in any country, whether non-immigrant visa or immigrant visa. You cannot get visa to return to the US for a period of 3 years. It is called 3-year bar. Now, every time you overstay for 1 year or more, anytime you step out of the US, you are barred from returning to the US for a period of 10 years. 10 years. That is what is called 10-year bar. Anytime you overstay for a period of 1 year or more and you step out of the US, you cannot return to the US for a period of 10 years. That is what is called 10-year bar. Now, anytime you overstay in the US for a period of 1 year or more and you departed the US and you now re-enter the US illegally, you are permanently barred from returning to the US. So, to go back to this question, this person has been out of status for more than 1 year. So even if the employer filed the petition on your behalf and the petition is approved, in the US, you cannot adjust status because this is employment-based and you have been out of status. And consular processing, you'll be barred from returning to the US for a period of 10 years. So you are subject to 10-year bar if you leave. So your employer may have good intention, but they don't know the law. So that is why it is important to break it down and to explain it to you in a way that will be very clear. So this is not an option for you if you are planning on returning to the US. Next question, please.
No, it's,
Yeah, I know. I mean,
yeah.
I know. I'll just maybe you mark that where that question is. That will be the last one that I will answer for today. That one of 4. Is it 4 or 4? So that will be where I will stop for today. Okay. Are they going to call me for interview? Is this a continuation?
She asked the question earlier.
Do you remember what the question was?
Responded.
Okay. Are they going to call me for interview before granting my green card after my VAWA has been... Oh, this is the VAWA question. Okay.
Yeah.
My VAWA has been approved back in January 2024. Yes, they will call you for interview because what you now have pending is the adjustment of status. As I explained earlier, the VAWA is the petition. So the VAWA is not the green card. It is the petition. It is the foundation upon which your green card application is based. So in order for you to get the green card, you will still need to attend an interview. Remember, the application for green card, that is the I-485, that is where you have to answer all those questions. Have you ever been arrested? Are you here to commit polygamy? Have you ever been deported? All those questions, security questions in the 485, yes, it requires an interview. Even though during Biden administration, a few cases were approved without interview, but under the current administration, they have made it clear that they are not going to be waiving interview. So, especially for cases like this, so it will require interview. I know that under the current administration, they still approve family-based parent-child relationship if everything is straightforward and there is no out-of-status issue. So they can still do that. But in this case, you will be invited for interview. So that's it. The next question, please.
I don't understand this question.
There is no upload document on my portal after DS-260 submission.
And the one on top of that one. Right above it.
Okay, document to them by mail. Is that the beginning?
Yeah.
Document to them by mail, not upload online. They asked me to include document cover sheet. There's no upload document on my portal after DS260 submission. Could this be the person asking question about the
No, this is
daughter
another
for fingerprinting?
No, there's another person.
So I don't understand the question.
So I do know that for employment-based ones,
Uh-huh.
you don't upload the documents. You send them with a cover sheet
Uh-huh.
to the MVC, and they're not gonna show up on the portal. The only thing that employment-based can do is just to complete the DS260 online. That's what I know.
That's for employment bill.
But for family-based, yes, all the documents should be uploaded.
Well, we don't even know what the question is all about.
Exactly.
Can you just repeat what you said now? Let the listeners hear you.
Yeah, so what I do know is that for employment-based immigrant visas, you are supposed to send the documents by mail to the National Visa Center, including the cover sheet. So after submission, they're just going to let you know that they have become documentarily qualified, but they're not going to upload documents on the portal. And now for family-based ones, then yes, they're gonna see all the paperwork that was submitted, uploaded onto the portal, but they will have to do it themselves.
Thank you. Well, if your question is about that, I believe you got your answer. Next question. I want to risk it to 45.
Okay.
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 I'm sorry. Okay, this is the next one.
Okay. Sir, I have a pending immigration court master hearing coming up. My 2 kids' initial EAD expired 2 years ago, but I did not renew them, and they have just turned 14 years old. Is it advisable for me to request EAD for them now? Yeah, you are already in removal proceedings, so there's nothing to worry about. Yes, you can go ahead and request it. There is a saying that he who is on the floor needs not be afraid of falling. I mean, people get scared so that they are not placed in removal proceedings, but in your case, you're already in removal proceedings, so there's nothing to be scared of. Just go ahead and apply. Next question, please. Good day, sir. What will be your advice for someone who was arrested, fingerprinted at the police station, and also given a citation for driving while unlicensed 2019? Can he travel abroad with 10 years green card? Well, what this person didn't say was all this before or after the green card.
Okay, he sent this other question.
But I've traveled twice in 2024, no issues, re-entry. Yeah, he still didn't address my concern because he just said that was arrested, fingerprinted at the police station, given a citation. But he didn't say, did all this occur before the green card? Because that is key. If all this occur before the green card, is not an issue. But if it is after, that is when this person can be subject to secondary inspection under the current administration policy. But if this was all before the green card, there is nothing to worry about. Let's go next question. I just want to see as many as I quickly can do before I step out. I know I'm risking it, but...
I know.
Hello, sir. Is application for I-131 re-entry permit the same thing as parole? Does the 1,000 fee you just mentioned apply to re-entry permit for green card holders? No. This is not parole. It is different. Those who are applying for travel documents, those who are applying for those green card holders who are applying for for parole, no, those are completely different. The parole we are talking about is those people who did not come into the US with visa. Those people who wanted admission through the port of entry. It could be through the airport, it could be through the seaport, it could be through land port. But those who are attempting to come into the US without a visa and they are seeking parole, those are the ones that require the $1,000 fee, not those who are applying for travel documents. No. Next question. You see, it's very important that I answer this type of question so that people don't get misunderstanding about the $1,000 fee on parole. No, it's not this type of people. Next question. God bless you for all you do. Amen. If someone who is legal permanent resident got arrested for family violence and the case was dismissed, can the person travel to Nigeria or out of the US? Oh, yes, you can travel. The only thing I will advise you to do, have a copy of the dismissal document with you. Have it handy. You can email it to yourself so that even if you forget the paperwork in your at home or something, you will still have something. Yeah, but you can travel since it has been dismissed. I mean, a case that is dismissed is not a conviction for any purpose, either for immigration, for anything. Once a case is dismissed, it's dismissed. That's not a conviction. So there's no problem about traveling. The next question. Good afternoon, sir. I went for marriage interview since last October and we could not make it because my wife didn't include me in her tax. Never they promised to call us for another interview. Till date, we have not been invited. What can we do? Well, it depends on the strength of your case. If your case is solid, what I mean the strength, it means the relationship between you and your wife, whether this is a strong relationship. If it's a strong relationship, then do a service request, use congressional intervention. If it is not a very strong relationship, I will advise you to allow sleeping dog to lie. That would be my advice.
The person that asked earlier about the this one, the one that was given the citation.
Yes.
He said that that was before the green card.
Yeah, I already answered the question. There's nothing to fear on that one.
Yeah.
Next one. Hello, sir. God bless you more. My girlfriend that I am, is that a continuation?
No, I don't see it. No. You want to continue with the next one?
Yeah, let me do the next one because that one. Huh?
1 minute.
Okay. Good day, sir. I have pending marriage-based I-485 and I-130, which I have done interview but not approved yet, and another pending VAWA I-485 case, which I filed. Will the VAWA nullify the marriage-based? Well, it's not going to nullify it until you withdraw it. You will have to withdraw one for the other. You can't file VAWA and family-based at the same time. They are inconsistent because if it is the same petitioner that is petitioning for you, is the same person that is abusing you, then you have to withdraw one and go for the other. And because you are not the petitioner in the I-130 family base, you don't even have the authority to withdraw it. What I will advise you to do, especially if you have filed for divorce, send a letter to USCIS, notify them that your marriage is no longer in good standing. You have actually filed for VAWA and that you want to, you are no longer interested in the marriage base, and let them know. If you have received notice of the VAWA, let them know also so that they may probably keep the I-485 for you and you will not have to pay another filing fee. That would be my advice. What?
We got one question through Facebook. I don't know if you want to address that one.
Okay, because this is Facebook, let me just...
Yeah.
Good afternoon, good evening, sir. Is it advisable for B1, B2 not to go back to his or her country? As in to stay here. If you don't have a means of remaining legal, it is not advisable. Well, for now, I think I will have to leave. As I said, I have to rush to court. That is one of the reasons we started early today, so that I will have enough time to answer as many questions as possible before I leave. I have to be in court in another 14 minutes. I have to leave right now. For the benefit of those who joined late, we just announced that last week too we started the podcast early because I was going to be in court, and of course it was a major trial. It was an asylum case. By the end of the trial, I got the case approved. So I want to give you the feedback on that, and also as a follow-up and as a way of thanking our listener, we are also introducing free consultation, one free consultation every month beginning next week. So next week we will be selecting one of our listeners to get free consultation. If you don't need free consultation, please do not waste the opportunity for those who really need it, because we just want to do this to kind of give back. So if you don't need it, don't waste the opportunity for those who really desire it. So if you desire the free consultation, there are only 3 requirements. Number 1, subscribe, because we are going to select the winner from the list of subscribers. It doesn't matter how long you have been subscribing. We have been doing this podcast for years. Some people may have subscribed for more than 2 years. Some may just be subscribing now. It doesn't matter. We are just going to go into the list of subscribers and pick the lucky winner. And also, because we are starting next week, during the live podcast, anyone who is interested, we chat with us, free consultation. So that will let us know that you are really interested. Again, I plead with you, if you really don't need it, don't compete with those who genuinely need it, because I desire that we provide this free service for those who genuinely need it. I hope to see you again next week. Until then, stay out of trouble, and I remain yours truly, Dr. Olu Asekun.